It's hard to imagine society without a legal system, especially a large urban society. Anyone who was wronged would have to seek personal retribution or do nothing and accept what had happened. It'd be chaos. Most of us depend on courts, judges, standards of evidence, and accepted penalties to help maintain order. Many people assume that organized justice is a relatively recent development, and yet the first structured and fair legal system was in ancient Mesopotamia. During the reign of King Ur-Ninurta of Isin in the 19th century BCE, a murder came to the king's attention. A priest named Lu-Inanna had been killed in the holy capital city of Nippur. This was no small matter. Lu-Inanna was an important man, known to many, a pillar of the community. His wife was named Nindada, and they probably had children. Almost every couple did, whether biological or adopted. Someone had to inform Nindada about the murder of her husband. One would expect her to be horrified and demand justice. But she behaved in an unexpected way. She didn't immediately report her husband's death to the authorities. In the phrase used at the time, she opened not her mouth, covered it up. The murderers were identified almost at once, 3 of them, and they constituted a strange group. One we know only from his name, Nana Sig. Another was a slave who belonged to a gardener. The third was a wealthier man, a barber. Barbers were trusted members of society. It must have unnerved many people to hear that this man, who so often had held a sharp razor to their throats, had also killed someone, a priest no less. Did the murderers act alone? And what reason might they have had to kill the priest? Suspicion began to fall on Nindada herself, the priest's wife. Perhaps she had asked the men to kill her husband. Most legal cases in Nippur would have been brought before a panel of judges to weigh the evidence, listen to the witnesses, and render the verdict. But this one was evidently too complex. Instead, it was taken to the king in the city of Isin. Even so, King Ur-Ninurta decided not to hear the case himself. Kings in Mesopotamia served as a one-man supreme court. But they didn't have time to attend to every dispute that came along. So King Ur-Ninurta referred the case back to the city of Nippur, though not to the judges seated there. Instead, he announced that the trial would be decided by the assembly. The assembly was a group of men who met periodically to help decide important matters. It was made up of men from all walks of life. We don't know where they met. Perhaps it was in an open area near the gate to the city, or in a courtyard of a temple. The accused men, along with the priest's wife, were brought before the crowd. And the men would have known that their situation was hopeless. There was no doubt about their guilt. But Nindada, the victim's widow, stood a chance of being released. After all, no one had heard her ask the murderers to do the deed. It was just her reaction to the news that troubled everyone. It was so strange. Now, a woman wanting her husband dead was not unheard of. A wife had few options if she was in a bad marriage. According to the laws, for a woman to be allowed to leave her husband, she had to be able to prove to the authorities of her city quarter that she had a perfect reputation and had been unjustly maligned by her husband. The city authorities would send out investigators to ask the couple's neighbors and friends about their behavior. And if her story held up, if she was completely blameless, she'd be allowed to return home to her parents, taking her dowry with her. If her story didn't hold up, she'd have to stay with the man who mistreated her. Some women in this era managed to negotiate prenuptial agreements in which the penalty for seeking a divorce was simply to owe alimony to their husband. But that was a rare situation. Most Mesopotamian marriage contracts, and many survive, offered a different resolution. If a woman wanted a divorce, the legal phrase she had to utter was, "You are not my husband." But she was more likely to be bound and thrown into the water for saying that than allowed to leave. and if she were tossed in the water, unable to free her hands and swim, she had no chance of surviving. So the men of the assembly might have already been suspicious of Nindada. Perhaps she'd shown signs of being less than fond of her husband, the priest. At the trial, the first men to speak had no sympathy for the murderers or for Nindada. 9 of them took the floor in front of their fellow citizens to speak their minds. These were not rich men, as far as we can tell. One was a bird catcher, another a potter, another one was a gardener. But they had every right to state their case. One of them shouted, "They are men who have killed a man. The 3 men and that woman should be killed." But he had an even better idea. Not only should they be executed, the execution, in a symbolic gesture, should take place in front of the chair of Luinana, the murdered priest. Perhaps the priest's chair could stand in for him so that he would, in a way, witness the death of his murderers. Nindada did have her defenders, including a soldier and another gardener, and they presented their case next. They asked, did Nindada in fact kill her husband? What did the woman do that she should be put to death? They had a point. No one had argued that Nindada was present for the murder. If she was not there, was it fair to kill her in punishment? Now, the death penalty for murder was a given, but hiring hitmen, was that the same thing? And could it be proved that she had done so? Presumably, some deliberation followed, and ultimately the assembly reached a decision. The court record notes that the assembly of Nippur took the floor, and one of their leaders announced the ruling. The statement begins this way: "A man's enemy may know that a woman does not value her husband and may kill her husband." Now, what they meant is that a woman would know of her husband's enemies, and such an enemy could be convinced to kill the husband. The verdict continued. She heard that her husband had been killed, so why did she keep silent about him? This was the deciding factor in their minds. An innocent woman would have immediately reported the murder. Nindada's silence implicated her. So, they concluded, it is she who killed her husband. Her guilt is greater than that of the men who killed him. The court record concludes, in the assembly of Nippur, after the resolution of the case, the 3 men and Nindada were given up to be killed. This court record is unusual in many ways. For one, it pertained to a murder that resulted in the death penalty. Most surviving Mesopotamian court records deal with much more prosaic problems, such as property ownership and inheritance disputes. Also, the usual workings of the legal system, judges, witnesses, and oaths, aren't in evidence here. This case was decided by mostly uneducated men and their gut instincts. We have a lot of evidence for how the legal system functioned during the Old Babylonian period, from around 1900 to 1600 BCE. There are many more records of court cases and several collections of laws and thousands of legal contracts. Plenty of personal letters also refer to litigation. The Mesopotamians and Syrians in the Old Babylonian period kept copious records of their legal activities. If someone bought or sold something important, a house or an orchard, a field or a slave, he or she often had a written contract drawn up that listed all the terms of the sale, along with the witnesses who were present. The same was true when a child was adopted, or when a marriage was negotiated, or a servant hired, or a loan made. These contracts, written on clay tablets, were kept in the person's house and were available to be consulted later if anyone challenged the terms or claimed to have a right to the property. If someone did contest a contract, then the legal system kicked in. And because the Mesopotamians kept so many records, often we get a sense of what happened. Let's look at another court case. This one for something less heinous than murder and much more common. It was an inheritance dispute. In the city of Sippar, southwest of present-day Baghdad, there was an extensive temple complex dedicated to the sun god Shamash, which was home to a group of religious women known as Naditus. The term Naditu is sometimes translated as priestess sometimes as none, but neither of these is really accurate. The Naditus prayed to the sun god for the welfare of their families. Often they had been sent to the temple by their parents for just that purpose. One such woman, Amat Shamash, owned a very small house in the temple complex. When she died, the house passed to her adopted daughter. This was typical and uncomplicated. However, Amat Shamash was also survived by two brothers who claimed that her daughter, their niece, had no right to the house. The men went to court. Their claim was that Amat Shamash did not bequeath to you any house whatever and executed no document in your favor. Upon her death, you yourself drew up such a document. In other words, they were asserting that the will was fake. Fortunately for the daughter, whose name is unknown, she had kept her mother's will, which, like all contracts, was written on a clay tablet. In it, her mother had bequeathed the house to her. She also had the names of witnesses who'd been present when the document was drawn up. They were listed on the will and were identified by their names and by the father's names or professions. This will might have been many years old by this time, and some of the witnesses might well have died, but some would still be living, and the daughter would have kept the contract right in her mother's house. Witnesses usually included relatives and friends of the parties to the transaction, so some of them would have been easy to find. But perhaps it took several days for the daughter to track down the other men and women who had been there when the contract was written. When she found them, she asked them to come to the trial. The court record tells us that when the day arrived, the trial took place in the Shamash temple complex where the daughter lived. She probably walked a short distance from her home to the proceedings, taking with her the inscribed clay tablet on which the will had been written long before. Her witnesses were in attendance, along with her uncles, and a panel of 5 judges, led by the chief judge of Sippar. After the uncles made the assertion that their niece had fabricated the will, the judges no doubt looked at the cuneiform document. Did it show any signs of having been written just recently? The judges then had 3 holy objects brought into the court from their shrines, 2 symbols of the sun god Shamash and 1 of the goddess Ishara. These would have been made of precious metals, and they substituted for the god and goddess in cases like these. Shamash was the god of justice, and Ishara was the goddess of oaths. Both could be expected to know who was telling the truth. The men and women who had witnessed the contract being drawn up were asked to swear an oath in the presence of these powerful symbols. They had to swear that Amat Shamash, while still alive, had bequeathed the house to the defendant and drawn up the document. The men and women did so willingly. This fact alone was the nail in the coffin of the uncle's case. The Mesopotamians believed the gods would punish anyone who swore a false oath. You could be sure that the gods' punishment would be rendered eventually, and you would live in fear until it happened. At the same time, swearing honestly about something that you had witnessed kept you in the good favor of the gods. Evidently, the uncles had no witnesses to back up their claim. The judges decided in the woman's favor and told the men they couldn't bring the complaint again. This ruling also applied to any other brothers who might have had similar ideas of cheating their niece out of the house. The house now officially belonged to the daughter of Amat Shamash. It's interesting to note what was not mentioned in the court record. There were no lawyers and no jury. Those roles hadn't yet been invented. And no fine appears to have been imposed on the men who brought the case. No one was punished. As was often the case in Mesopotamian court records, the judges decided not in favor of the more powerful party. In this case, that would have been the uncles. Instead, the judges supported the weaker party, the adopted daughter. Their concern seems to have been on the side of truth and justice, not of power or political favor. There's also no reference to the judges consulting the law. The witnesses and the written contract and the presence of the gods were enough to decide the case. In fact, there are almost no references in Old Babylonian court records to the judges consulting written laws. The laws played an ambiguous role in the judicial system. This might be surprising, since the invention of law is one of the many important firsts often credited to Mesopotamia. But written laws were less important at the time than the judges, evidence, courts, contracts, and lawsuits. Hammurabi of Babylon wasn't the first lawgiver, though people often have the impression that he was. The honor is actually held by King Ur-Namma, who ruled several centuries earlier. But Hammurabi's laws are the best known from Mesopotamia. In part, this is because he inscribed the laws on an impressive 7-foot-high polished stone stele, with an eye-catching depiction at the top of himself with the god Shamash. Shamash is seated on the right, handing a rod and a ring to Hammurabi, who stands in front of him, with his hand raised in prayer. The laws cover the rest of the stele. The stele was placed in a public square for all to see. Hammurabi wrote in the inscription that he'd established the laws because the god Marduk told him to, and doing so would bring appropriate behavior and enhance the well-being of the people. The well-being of a well-behaved people, that was his goal. The monument was later stolen by the neighboring Elamites when they sacked Babylonia, and thousands of years later, it was excavated by French archaeologists in the Elamite city of Susa, in modern-day Iran. It ended up in the Louvre Museum. It's still breathtaking. At the time when the historic stele was found, right at the beginning of the 20th century, it was the earliest known collection of laws, and it made the news. Overnight, Hammurabi became an important figure in history. But his laws were also well known in his own land, and not just in his own time, but through the generations. Scribes copied the laws and studied them in a way that had not been true of the laws of Hammurabi's predecessors. Of the approximately 282 preserved laws that Hammurabi proclaimed, many deal with circumstances that can't really be described as crimes at all. They govern such things as the circumstances when a divorce was permitted, how to compensate for property losses resulting from storms or negligence, who could ransom a captured soldier, what to do if an ox gored someone, and what the punishment should be for failing to pollinate a date orchard when hired to do so. It makes sense that these types of things dominated the concerns of average Babylonians, people like farmers, homeowners, and tradespeople. Only 25 of the laws, about 9% of Hammurabi's collection, address violent crimes. Of these, 10 are the often quoted eye for an eye laws that pertain to a man's breaking another man's bone, or striking a man's cheek, or blinding an eye, or knocking out a tooth. Most of these sound like the results of fistfights, and no weapons are mentioned. Interestingly, the accused is always assumed to be a member of the upper class, called an awilum. If one of these men broke the bone of a member of his own class, then his own bone would be broken. This is the so-called lex talionis, the law of retaliation, which is also found in the Bible. But if the aggressor broke the bone of a commoner, that is, a mushkenim, then the upper-class man had to pay a fine. This sounds as though it's unfair. Why did the commoner receive silver instead of having the pleasure of knowing that his assailant's bone had been broken? Well, if you were a commoner, you'd probably want the money to compensate for your broken bone, and you'd want it more than you'd want vengeance. And the amount that a commoner received from his attacker was 60 shekels of silver. Since a laborer earned around 1 shekel a month, this was 5 years' salary. I doubt that most commoners thought this was an unfair deal. Anyway, 6 of Hammurabi's laws address punishments for striking a pregnant woman and causing a miscarriage or the woman's death, probably as a result of domestic violence. One law directly addresses a son striking his father, for which his hand was supposed to be cut off. But we don't know of any case in which this was actually enacted. 5 of the laws punish what we would call rape, though in only one of them is the woman clearly described as the unwilling victim, and in that case, she was not to be punished. Her rapist, on the other hand, was to be put to death for his crime. The other 4 laws dealt with sexual assaults in a family. A man was punished for having sexual relations with his daughter, mother, or son's fiancé. The woman probably was unwilling in these cases as well, but that isn't specified. 2 other laws addressed deaths during crimes. In one, a victim was beaten to death while detained by a creditor. In another, someone was killed during the course of a robbery. And finally, one law, just one, concerns premeditated murder when a woman had her husband killed because she was having an affair with another man. That's it. Hammurabi didn't include a law to determine what happened when a man murdered another man, or if a man murdered a woman, or if a woman murdered a man for a reason other than an affair. These scenarios aren't covered. There are tons of gaps like this. The laws don't even try to be comprehensive. They appear instead to be a collection of past legal decisions that the king wished to support. Judges might use them for guidance perhaps, but they don't exactly represent a code of law. Some of the other laws are about lesser crimes, such as robbery or false witness, or malpractice. And most really aren't about crimes at all. They determine what should happen when complications arose in everyday life, in marriages, divorces, inheritance distributions, loans, military service, agriculture, trade, and so on. Clearly, people worried about marriage and sex. Many of the laws governed what happened, for example, when someone accused a woman of adultery, or when a man wanted to take a second wife, if he'd been unable to have children with his first wife, or when a man had debts before he got married and hadn't paid them off, or when a man broke off his engagement. Hammurabi also included plenty of rules about inheritance, who had the right to inherit and who didn't. The court records tell much the same story. There was a great deal of litigation about property and inheritance and divorce, but not much mention of criminal behavior. Even though I started this lecture with a death penalty case, very few known court cases ended in capital punishment. The judges tended to be much more lenient than the laws might have you expect. And there were no prison sentences, because there was no concept of prison as we know it today. For the most part, if someone could continue to participate in society, he was fined. If he was a danger to society, he was killed. Hammurabi's laws give us intriguing insights into the legal system. Several of them mention the river ordeal. This was a way of determining the truth if there were no witnesses to put under oath, when only the gods would know who was telling the truth. For example, if a man's wife should have a finger pointed against her in accusation involving another male, although she has not been seized lying with another male, she shall submit to the river ordeal for her husband. In theory, what would happen is that the accused woman would be required to jump into the river. If she drowned, then the gods were showing that she was guilty of adultery. If she survived, the gods had saved her because she was innocent. She was not bound in any way, so if she could swim, she stood a good chance of survival. In practice, the mere threat of the river ordeal was often enough to reveal the truth. An innocent person would agree to it readily, knowing she would survive. A guilty person would rather confess than be drowned in the river, the penalty the gods would undoubtedly impose. So the person's reaction to being sent to the river was often enough to prove guilt or innocence. They didn't necessarily have to be subjected to the ordeal. Other laws in Hammurabi's collection deal with the issue of taking an oath. If someone was willing to swear an oath, to give evidence before the god, it was considered proof that the person wasn't lying. No one would be crazy enough to lie in front of the gods. They were so powerful. So, for example, if goods had been stolen from someone and the robber hadn't been caught, the law stated that the man shall establish the extent of his lost property before the god, and the city and the governor in whose territory the robbery was committed shall replace his lost property to him. In other words, if the victim would describe before the gods what had been stolen from him, that was an assurance that he was telling the truth. And the order that the lost property should be replaced was a kind of insurance against theft. The oaths and the river ordeal reflect the deep faith that the Mesopotamian people had in their gods. and they helped the judges determine the truth of a case. The laws were all conditional in structure. None simply stated that one should not do something. That would be an absolute law. They all noted that if someone did a particular thing, then this or that punishment would be imposed. They reflect a basically law-abiding community, in which people sometimes gave in to their baser instincts, but in which everything could be worked out. No one had to take the law into his or her own hands, no matter how much he or she had been wronged. Some of the laws might seem harsh to us, but the legal system was considered fair and humane in Hammurabi's time. Thousands of records survive from Hammurabi's era, the Old Babylonian period, reflecting intimate details of people's lives. Reading them, we glimpse human concerns and the successful ways that people used the courts to reach agreeable settlements. It's also striking to note the lack of corruption in the system. As Hammurabi wrote in the epilogue to his laws, "Let any wronged man who has a lawsuit come before the statue of me, the King of Justice, and let him have my inscribed stele read aloud to him. Thus may he hear my precious pronouncements, and let my stele reveal the lawsuit for him. May he examine his case, and may he calm his troubled heart." The laws and the courts in Mesopotamia were designed to reach just decisions and to allow even the weak in society to obtain justice. It was an effective system that lasted hundreds of years. It also inspired many later legal systems, not just in the Near East, but around the world.